This is This Week in Perspective with B. Adam Simbe. A number of African countries have indicated their desire or decision to withdraw from the International Criminal Court in The Hague, which is normally referred to as the ICC. Africa, the largest bloc in the Rome Statute, is among the founding 124-member organizations, which are signatory to the Rome Statute, again, which established the court. To discuss the ICC and Africa withdrawal and accusations that the ICC is biased against Africa and what should be done, whether we are in the right track, and whether this ICC is really beneficial, it benefits the Africans and whatever. With me today are Professor Koti Kamanga from the University of Dar es Salaam.
Thank you.
Congratulations.
Thank you.
For your appointment as professor. Professor Mohamed Bakari from University of Dar es Salaam. Now, to distinguish a bit of the two, he is from the Political Science Department, Political Science and Public Administration Department from the law school. Professor Chris Maina Peter from the law school.
Thank you very much.
Last but not least, a lady to break the gender imbalance. Gift Quaker from Open University, and Ongera, she will soon complete her PhD from the University of Dar es Salaam. But you remember the beautiful professors, they were your teachers. Well, ladies and gentlemen, welcome to the program.
Thank you again.
I hope in the next 55 minutes we'll be able to provide information, to analyze the situation, and benefit the powers that be on the need, importance, or otherwise of the ICC. Let me start with the very first question, and I'll ask Professor Peter to respond, and then all of you will respond as well. And I'm saying here, for the benefit of the viewers, what is the International Criminal Court, or the ICC? When, why was it established, and who are the members? Professor.
Thank you very much for your very important question. I think to understand the ICC, one has to understand the situation before the court was established. There has been a tendency among members of the international community, whenever there are serious crimes committed, very serious crimes, the tendency has been to establish temporary mechanisms to deal only with that temporary measure,
yes,
thinking that this is not a permanent phenomena, we are going to deal with this and then we are going to finish it. For example, after the Second World War, we had problems of serious crimes being committed. And then we established two temporary courts, one in Nuremberg in Germany and another one in Tokyo, in Japan, to deal with main criminals, the authors of crimes of the Second World War. And then after finishing those cases, the two tribunals were disbanded. And then again, 1993, there were problems in the Balkan, former Yugoslavia, and there were serious issues of genocide and so on.
Yes.
So we established a temporary mechanism again, the former Yugoslavia tribunal, to deal with that.
Yes.
1994, we had a problem in Rwanda.
Yes.
Genocide again. So we established the Arusha ICTR, International Criminal Tribunal for Rwanda. So there has been a tendency of establishing temporary mechanism to deal with the serious crimes against humanity. So the International Criminal Court, which is established under the Rome Statute of 1998, is the first permanent mechanism to deal with the serious crimes.
Yeah.
So it is a court which is there permanently to address 4 types of crimes. Number 1, genocide, war crimes, crimes against humanity, and now they have added aggression, the crime of aggression. So, so this is the first mechanism we have in the world to deal with the serious crimes, because these are very serious crimes. But again, let me add, before I allow my colleagues to compliment, that unlike the normal courts,
Yes.
the International Criminal Tribunal is not a court of first instance. That is, you don't go to ICC to start a case. These serious crimes are supposed to be handled by national states, ourselves. It is only when we are unable to do these crimes, or we are unwilling, then now the court comes in as a complementary mechanism.
Does the court come in, or we go to the court after?
My colleagues will explain. There are two ways.
Yes.
There are basically two ways. The court itself can come,
Okay.
and it can also be triggered by the
national court.
the Security Council
Of the United
of
Nations.
the UN
Yes.
Security Council. We shall discuss the problems with that trigger mechanism.
Yes.
But maybe my colleagues want
But
to.
you've, okay, they will answer the next part. Who are the members? Professor?
Yeah, I'm happy that you raised this question, these very, very basic questions.
Yes.
Because sometimes when you are, for example, in this public transport, you hear conversations, there's a pickpocket has been captured, and people are saying, I think we should take him to The Hague, you know. So yeah, so it is gone to that level. I think there's a lot of misunderstanding about what exactly does this court deal with, and I think the professor has made it very clear that it's dealing with serious crimes. But and then I'm happy also that we mentioned the history.
Yes.
Right? We really should know where it has come from. And I think here one of the most important things is that in addition to the problems of being ad hoc, which have been going on since World War I, actually, and after Leipzig, right? Same approach, ad hoc, it didn't do anything. And even before then, up to 1474, actually, the people have done research. Even up to then, it was the same approach, ad hoc, disbanding, but the problems continue. So this has resulted in what is known as impunity. People know that they can do these things, they can commit war crimes, they can commit genocide, but they'll go scot-free. So I thought it was important. But thirdly, what I thought was also important, and it appears in the speech of the Tanzanian delegation, is the role that Africa played in the negotiation process of the Rome Statute.
Before we go there,
Yes.
who initiated even the Rome Statute and the whole question of having a court like this, so that we don't have ad hoc mechanism for prosecuting this problem?
My recollection is that within the United Nations, I think within the International Law Commission, Professor Peter will confirm here, it has been going on for years. Actually, there was a draft of 1994, isn't it?
Yes.
On 1994. So it's been going on for long, right? So yeah, so going back again. So the negotiation process of the Rome Statute, Africans took a very, very active part. And not simply participating in negotiation, the normal negotiations, but even being assigned to head certain working groups.
Okay.
Yeah. And interestingly enough, one of the working groups was chaired by Tanzania.
Oh.
Yeah. And another working group was chaired by a South African, but who happened to be a Tanzanian, Professor Lamira.
Is that so?
Yeah.
Okay.
Then
okay.
Kenyan were heading another committee, another one by a lawyer from Lesotho, Pakiso Mochochoko, right? So this is the truth of the matter. This is the truth of the matter. The Rome Statute and the ICC were not brought to Africa, but we as Africans collectively took the most active part. And incidentally also, I must say, even NGOs, right? There were more than 236 accredited NGOs, and we were also part of that process.
So how many members? What's the number of the members of the Rome Statute? Do you call it the ACPs, whatever?
Those who have signed and
let's start with those who have accepted it and signed. Maybe they've not ratified. But
yeah,
at least.
Here in Africa, we are in three categories. My colleague here maybe has better statistics. There are those African countries who are not part of the Rome Statute. They've not signed on.
Okay.
Right? There are those that have signed and ratified, and that's where we belong.
Tanzania.
Tanzania.
Okay.
The others, they've gone a further step. They've signed, they've ratified, but they've even adopted a parliamentary act to domesticate, to give the statute a force of law in national territories.
Okay.
Yeah.
Let's look at the, I'll come to you, Let's look at the political aspect of this ICC, you being a political scientist. What's your take on this?
Well, I think the realities of the time that crimes against humanity that were committed during that time was, of course, should be viewed within the context of international politics. And therefore, if we are talking today of, let's say, inequalities among member states,
Yes.
we have to realize the fact that we have to recognize that the international community is not arranged, fairly. There is a lot of politics in it. That's why some of the major powers like the United States, Russia, China, they are not actually party to the Rome Treaty. Or some of them that initially, for example, said that okay, they would sign or ratify at some point, but some of them they withdraw, and some of them now, like Russia, they have indicated that they don't intend anymore to be part of the treaty. So, why the small powers are essentially maybe the basic actors in this particular arrangement? I think that's the reality of politics. In terms of the kind of crimes that are taken into account, primarily it's those crimes that are committed within the nation states. Although there is also provision for war crimes that can be committed in other countries. But the primary reason for the establishment is the crimes that are committed within the nation states. And the assumption is that the developed countries, particularly the highly developed countries which are more democratic, they have their domestic mechanisms to address these problems. But most of the small powers or developing countries, they don't have elaborate and effective domestic mechanism to address these kind of problems. Because if, for example, developing countries that are members of this institution, of the ICC, if they would have an effective system of the judicial system in their own countries, I think there will be no reason for the establishment of the International Court of Justice, because they will be resolving these problems using their own domestic systems. But because they are not effective, that's why there was need. The fact that some of the major powers also signed the treaty and they ratified and they are part of the International Justice, that was a sort of a kind of diplomatic kind of gesture that we are also party to this. But those who are not the primary members that were meant that they will be served by this treaty. It was a kind of diplomatic gesture. That's, you see, even the countries like the UK, Germany, France, they are also part of this. That is kind of diplomatic gesture, because I also believe that in terms of addressing their domestic problems, crimes that are committed within their territorial boundaries, they have effective judicial system to deal with them. The problem will now come for those crimes that are committed in other countries, like the United States, for example, the kind of crimes they commit in countries like Afghanistan, in Iraq, in Syria, or wherever. Then maybe that could be the reason for the establishment maybe of a judicial system. But otherwise, I think the primary reason for the establishment was dictated by the ineffectiveness of the domestic judicial systems to handle such kind of problems.
I wonder how they measured the effectiveness of the national judicial system. I mean, as you rightly said, each country has its own judicial system, which is created by the country's constitution. So, how did they manage to do this? I mean, how did they come to a conclusion that because of the inefficient national judicial system, then maybe we should go outside and have this kind of water?
Well, I think there are so many objective indicators to measure. There are so many objective indicators that you can use to measure, the ineffectiveness of the domestic judicial systems in our country. You could look, for example, at the human rights index among countries in the world, for example. Violation of human rights in these countries. You can look, for example, issues like electoral violence. There is no country, for example, among the developed democracies which has sort of, let's say, electoral violence. But here, electoral violence is widespread, for example.
Until recently, you were saying.
The
No,
US.
that's not violence.
Demonstrations.
No, that's not violence.
Okay, all right. Okay.
So I think there are so many objective indicators that if you look into the, I mean, there are so many studies, there are so many reports. Maybe I mean the lawyers could tell us. I mean, the democracy index, human rights index that are used to measure the levels of observance of human rights across countries.
All right. I mean, it could be debatable who writes, who prepares those reports. Anyway, the only lady on the table, my apologies to ask you to come in after the three professors have said, but being a lawyer, a student of international law, and having worked on these and doing a PhD, I suppose, in some of these areas, what do you say to this? I mean, what all the professors said is it has actually opened up the discussion and the minds of Tanzanians that this is a special court, all right? More or less a permanent, not an ad hoc, as it were, from the beginning. Yes?
Thank you so much. First of all, I would like to comment on the historical part in the development of international criminal law up to the leading of the establishment of the International Criminal Court. For me, what is striking is the role played by Africa in all the development of the international criminal law. If you check at the period when international criminal law was incepted in 1945, with the first ad hoc tribunals, really Africa had no position to play. Most countries were under colonial domination, so they didn't play any role. When you come to the 1990s, for the first time you see the ICTR, Rwanda, coming into play. But most significant is with the ICC. You see Africa taking center stage in the development of international criminal law, particularly in the creation of a permanent court. So for me, Africa moved from being passive, yes, to being active players in international criminal law development. As we stand today, there are 34 member states from Africa, which is the biggest number of member states from any bloc. But what Professor has said there in relation to the inability of domestic courts to prosecute these international crimes, one of the factors is the unavailability of domestic laws to prosecute international crimes domestically. For example, it is only of recent that you see some countries, very few African countries, for example, Kenya, Rwanda, Uganda, South Africa, Mauritius, DRC, yes, they have like elaborative legislative framework for the prosecution of international crimes. And without the laws, really, the courts cannot do anything because they need the law in order for them to adjudicate these international crimes. So if you don't have a law that provides for crimes against humanity, war crimes, genocide, and the crime of aggression, actually we shouldn't put in the crime of aggression, these three crimes, then the courts cannot do anything. The only thing they can do is to prosecute those crimes as ordinary crimes. And that is what has been done over the past. For example, in Kenya, they have tried, even to a minimal role, to prosecute the crimes against humanity in the post-election violence as ordinary crimes, not as international crimes. So the main crippling factor is the absence of legislative framework, among others, weak judicial system, the inability to investigate, the lack of trained people. There are so many other factors that can contribute to that.
Well, I being a non-lawyer, but of course I follow the issues, I would have thought, or at least my understanding was that some laws can emanate from the decisions of the court. I don't know whether this is possible. I mean, case histories would indicate that 5-6 years ago, similar incident was reported, and there that becomes a precedence in any decision in the future. Is that correct?
Yeah, generally correct. But in this particular case, that's what we were saying. You know, after World War I,
yes,
right, the Treaty of Versailles, right, created a tribunal to prosecute those who were responsible for serious war crimes.
Yes.
Ad hoc, Professor.
Yes.
Ad hoc, right? So they did that and then got disbanded. And then, okay, again, we sat with our hands folded until World War II. again, ad hoc. So in situations of that nature, to carry on the reasoning in the field becomes difficult. Right? It becomes much easier, as is the case now, when you have a permanent standing body. Right? Then jurisprudence will develop much more coherently, if I may put it that way. Yeah.
So the Yugoslavia and the Rwanda in Arusha Tribunal all came after or before the ICC?
Of course, before.
They are products. They are products of ICC or
No, before 1993, 1993 Yugoslavia, 1994, 95 actually, because the genocide was 1994.
Yes.
It was all before ICC. The Rome Statute was 1998.
Okay. Now that you're on the floor, Professor, let me ask you very quickly. So, to date, how many cases has the ICC dealt with, and how many of these are from Africa, and how many are from outside Africa? Because that will lead us to the next question, which is very fundamental.
Yes.
Why Africa wants to move?
The guilty are afraid.
Before I answer that, I just want to compliment a bit on what Gift has said about non-availability of the law, of international law, because we did a research on how international law is used. Because, for example, we use the Penal Code in Tanzania.
Yes.
The Penal Code of Tanzania is of 1945. So, for example, when pirates from Somalia were caught by EU and others on the Indian Ocean, they couldn't prosecute them because piracy is not in the law. So the Penal Code had to be amended to include the piracy in order to bring in these pirates from Somalia.
Yes.
So I think what you say is very fundamental, that our laws, do not provide for these serious crimes. The only crime which you can try is war crimes, but then you have to use the Red Cross instruments where they have been domesticated to try and deal with the war crimes. But genocide, crimes against humanity, no way. I think that's the most fundamental. That's why, as Professor Kamanga is saying, that you need to first of all adopt the Rome Statute and domesticate it after signing and ratifying. Domesticate it so as to give the courts in Tanzania the basis.
Or in Africa, for that matter.
Exactly. Yeah. Now, coming to the cases, I think maybe Gift.
No, but if I could say something on that,
yes,
the absence of law is not only the only problem. You may have an elaborate legal system, but if the political arrangements in place is not capable of implementing it, it's not going to implement.
And that's
look
what,
at our
that's
domestic
why I
judicial
wanted
system.
to have you.
Look at our domestic judicial system, for example. We may have an elaborate law, for example, on corruption, but who are, what kind of people are sent, to court and prosecuted?
Small fish.
The small fish, the big ones cannot be touched,
No,
So even if we are going to have a kind of an elaborate legal system dealing with the crimes against humanity, war crimes, and so on, I think the willingness to prosecute is a different matter, and therefore that's why there is also an urgency of referring these cases to a body where they can be prosecuted.
But Professor, the extreme bit would be that, okay, so let us abandon the issue of having an ineffective legal system. It's enough to have a political will. I think that will be the extreme. I don't think you're going there. I don't think you're going that far. But I agree with the good professor here that having an elaborate, effective working system, legal system is important, but it's not enough. For example, in DRC, there is a very interesting scenario. The DRC has signed and ratified the Rome Statute, and because of the nature of the legal system, then that treaty automatically becomes part of the laws of the DRC. But now the treaty has gone to Kinshasa. It finds that it is cohabiting with a statute which deals with military law. So now the judiciary is applying not the statute, but they apply, which is in conflict with the
32.
Yeah, so as a lawyer, of course, I always insist that it is important we should sign, we should ratify, domesticate. But quite agree with the professor here that it requires more than that for the law to become alive and biting.
Gifts. I saw Professor was referring to was more or less asking you to go into my last part of the question to him. How many cases?
Yeah, I think first of all, before I say how many cases, I would like to say there is when in the ICC there are things we call situations, which are referred to the court, and then out of the situations, then you emanate cases.
Yes.
So far in the court we have 10 situations from different 10 countries, and we have
10 African countries.
No, 10 different countries.
Global.
9 of those countries are Africans. One is Georgia. It started this year. But we have 18 cases. Out of the 10 situations, they are opened only 18 cases, and all of them are from Africa.
But then there are cases which are actually referred by African states.
That's very interesting.
So we have to get it.
Can you cite one or two?
Quite a
Yes,
good number of them, actually.
Yes. Not only it's the situations that are referred by African, they call it self-referral. There are four situations, and that is Uganda, DRC,
Central African
Republic, and Mali. Yes.
How about Kenya?
No, Kenya wasn't a self-referral.
Okay.
Kenya was a different. They are actually, maybe we should elaborate about how situations are.
I think that,
There is also a case actually in Mali. It was referred by the government of Mali.
Yes, that's what
dealing
I
with
said,
the rebels. Yeah.
self-referral.
Yeah, that will benefit the viewers.
for the benefit of the viewer, I think we should put it simply like this: that cases can go to the ICC through the following means. Either it could be on the initiative of the Security Council, where the Security Council is saying that we have powers under the UN Charter, under Chapter 7, for purposes of maintaining international peace and security. And we see that the situation in that particular country is a threat.
Yes, not
Right?
ignoring that the members of the Security Council are the big four, the big five, the big six.
Yeah, I'll come to that.
Africa is not big.
We'll come to that.
Yeah.
So it could go there on the basis of the initiative of the Security Council.
Yeah.
Right? Other cases will go there because a party to the Rome Statute, right, will make a request, right, that we think this is a breach, there's a breach of the Rome Statute, so please handle this matter, right? As is the case we've just said, Uganda, Central African Republic, all these African countries, they themselves, on their own initiative, of their own volition, went to the prosecutor, we think you should deal
And
with it.
hopefully they were supported by their own citizens.
Of course, we assume so. But the third trigger is that where the prosecutor, on his or her own initiative,
Yes.
sees that this is a situation that is in violation, is in breach of the statute. So, suo moto, she takes up the matter, gets in contact with the state, seeks their cooperation to arrest, to find, to gather evidence. So, yeah. So therefore, when we are talking about Africa and the ICC, we must be able to distinguish which category of cases are we talking about. Because if it is cases that we as Africans ourselves
Yes.
took to the ICC,
Yes.
then it sound rather awkward to begin sing malice or something of the nature in the ICC. If it's issue of the Security Council, I would agree.
Yeah.
Because there again now the paradox is, the Security Council has power to refer matters to the court when some of the members of the permanent five, they are not parties.
Yeah.
So in essence, they are sending people they are insisting that we should use a judicial system, which they themselves have rejected, actually.
But in certain circumstances, I think it's also possible for non-state actors also to trigger the process. Not maybe directly, but maybe they can submit some kind of preliminary evidence to the prosecutor, and the prosecutor will develop interest in that particular case to pursue it. Yeah, so it's also possible for the non-state actors to, not to file a case as such, I think, but maybe they could trigger the legal process also. I think that's also possible.
But maybe an addition to what Professor Kamanga is saying, which is important, is that when the Security Council refers a case to the ICC,
Yes.
first of all, some of the members of the Security Council are not parties to the Rome Statute. And then they can refer a case about a country which is also not a member of the ICC, of the Rome Statute, like Sudan, for instance. And then more seriously, now there is a new issue that some of the members of the Security Council who are not party to the Rome Statute
Yes.
do not contribute to the funding of the court. So how are you taking the cases to a court which you don't even pay for? You know, so it's a more
And finally, there's also that funny provision where the Security Council can say, you know what, we have sent this matter to you, but hold on for a moment, don't do anything about it yet.
I see.
So there's
the
politics.
the court can
High
receive
politics,
these referrals from non-members of the Rome Statute, but is it obliged to take action when it has received something from a non-member?
Yes,
Yes.
yes, because it's a United Nations Security Council referral
Yes.
through a resolution. And I wanted to comment on the resolution that referred Sudan to
Yes.
to the ICC, resolution
Yes.
1593.
Yes.
It actually excluded on the funding part. It actually stated that the Security Council will not fund in anyhow. Actually, in para 7 of the
Oh
resolution.
dear, oh dear.
So it's very much interested in its own cases that have been referred from the Security Council.
Yeah.
I mean, when it comes to funding of the institution.
No. The funding of the institution is contributed by member states. But now here you have Sudan. It's not a member state. But now to conduct the proceedings of that particular situation, it means they'll have to use fund.
Yes.
But the Security Council, which referred Sudan, is saying we are not going to contribute anything.
Yeah, but there is a provision actually in the statute that the United Nations can also contribute to the functioning of the court.
But they don't.
But
Even
it's-
other parties are also allowed, provided that it won't compromise the integrity of the court.
Yes, but they said in the
the sources of
resolution
funding.
referring the situation that we are not going to contribute.
Oh dear, oh dear. All right. Now, all what we've said and analyzed in the last few minutes will lead me to ask, and anybody can come in. So, is it fair to accuse the ICC of being biased against Africa? And if yes, why do you think this is the case? And do you think the court has interfered with the efforts by African leaders as a result to achieve peace in Africa? Who wants to come in? Professor Mena or Commander?
Yes and no. Yes and no. Yes and no. As I said a while ago, cases can get to the ICC through different ways.
Yes.
Right? In those cases, certainly, where the state itself took the matter to the ICC,
Yes.
there can be no discussion that the ICC is biased.
Yes.
Because of your own volition.
Yes.
You had a chance, you had an opportunity to prosecute,
Yes.
but you voluntarily approached the ICC.
Yes.
Those that have been referred by the Security Council can invite that type of harsh statement. Now, take a country like Kenya. Kenya, post-election violence.
Yes.
All right. The Kenyan government itself appoints a commission to advise government how should we handle this post-election violence, who did what and what, right? The commission is advising government, right? What you should do, you should establish a special tribunal. Am I right, Professor?
Yes.
The Working Commission, right? The proposal is taken to Parliament that we have this proposal from this commission to establish. So we'll need the authority of Parliament, of course, to create an institution like that. Yeah. Parliament says no. Don't be vague. Let's go to The Hague. Right? So what does that legally what that meant? That meant that Kenya was unable or unwilling to prosecute. And once you're in that position, now you literally are authorizing the prosecutor now, right? Because you have been given the first shot, right? And you are shying away. You're saying no, we don't want to prosecute at home. We want to go to The Hague. Yes. So the prosecutor comes in. So in situations like those, can be no question of bias, right? Because you placed yourself, right, in a situation in which you left the prosecutor with no other option but for him to take on the case.
But recent development that we've seen, a number of countries deciding that they'll withdraw, is an indication that, or the reasons behind it just stand to be corrected, because they think the case is only meant for Africa and nobody else. Is that not correct?
That's not correct. I think I agree with you, Professor Kamanga, that one, there are cases which we have taken ourselves. There are cases where we have been given sufficient rope to hang ourselves. That is, we have been given opportunity, particularly the case of Kenya where Professor Kamanga is saying, the Waki investigation produced an envelope.
That's Wako, is it?
Waki.
Waki, okay.
He was a judge of the
Supreme.
Court of Appeal.
Yes.
He after their research, they actually identified the major
Culprits.
the major players, and it was put in an envelope. This envelope was given to the first prosecutor of ICC to allow Kenya to establish mechanism to deal with that problem. And then they said, no, just deal with the case.
That was the parliament.
Yes, Parliament, and those people who were eventually taken to the Hague, they were the ones saying that let us go to the Hague. So it is only when the envelope was eventually opened,
Yes.
after they were found to be unwilling and unable to prosecute, that they said, no, we have to establish an African system for Africans, which is not the case. I think the issue are people are taking advantage of what has been taking place and blaming the ICC. Of course, the argument is that there are similar situations elsewhere which are
Outside Africa.
Yes, which are sometimes worse than what is happening in Africa, which are not being addressed by ICC. That's where the question of bias comes. Because we know of situations which are worse, but ICC is comfortable only dealing with Africa. That's where the political argument comes in, but it doesn't absolve the problems we have in Africa. Only that the ICC should be reaching further. I think that's the argument. It's not that it's biased against Africa, only that it is not going further enough, being global. This is an international criminal court. It's not an African criminal court. So it should go beyond Africa.
Professor Bakari,
Yeah.
What I heard from Professor Peter, let me ask you this. Then you think this element of bias and unhappiness about the court, more or less accusation that it's focusing on African leaders, is it more of a political argument or legal argument?
I think this is largely a political argument. It's not a legal argument because there is no one who can raise a finger claiming that in a particular case the ICC was biased against somebody from Africa or a situation that had been referred from Africa. There is no such instance. In terms of the proceedings, the way the proceedings are undertaken, the way investigations are carried out, there is no that argument. So the argument is based on the fact that because this is a global institution, it's supposed to have a wider reach. It should go to Latin America, to Asia, everywhere.
Europe.
Europe, everywhere. So the fact that most of the cases are from Africa, it's exactly what has been said here, that it's because those situations that have been referred to the court are from Africa, and most of them they have been referred by the African states themselves, by the governments of the African states, actually, not by other. I mean, if you compare, for example, the number of cases that have been referred by the governments, for example, probably there are more than the cases that have been referred by the United Nations Security Council. So a good number of the cases, a larger number of cases have been referred by the African countries themselves. So I think that argument is not, it is largely a political argument, and as Professor Peter has clearly said that, well, the fact that the court has not been able to to reach other areas. It doesn't mean that those cases in Africa are not valid cases, are not genuine cases. They are genuine cases. But because this is a global institution, then the court has to project itself as a global institution, and therefore it should be able to handle cases from all over, over the world.
Professor Bakari, what would you say then to the news that the chief prosecutor says the U.S. Army committed international war crimes in Afghanistan, and therefore she might pursue this case, and then the American says it's a non-starter? What do you say to that?
Yeah, it is because of politics. It is because of the reality of politics.
Yes.
The ICC doesn't have the police force, it doesn't have the army, so it depends on the willingness, cooperation of nation states, to cooperate, and therefore, if, for example, I would cite an example, the case of, let's say, when al-Bashir was supposed to be arrested in South Africa.
Yes.
Would it, click to your mind that, for example, if such crimes had been committed by the U.S. president, could such a directive be would that be issued by the ICC to arrest the American president? The answer is no.
Oh, yes.
Because of politics, the reality of politics.
Yes.
How
about the American president coming to Tanzania, and when the general assumption is he actually committed crimes in Iraq?
Iraq.
Yeah, you cannot arrest him. Sure.
Tanzania would not
because of the reality. No, it couldn't. It wouldn't be able to do that. It's the reality of politics.
Gifty, what do you say to that?
Yes, you can't arrest, and I'll come into that a little while. But I want to comment on the biasness created by the United Nations Security Council.
Yes.
I think that is where the problem is.
One of the big problems.
Yes, the biggest problem, because you have two situations that have been referred by the United Nations Security Council to the ICC, and both of them are from Africa. That is Sudan and Libya.
Yes.
But you have, and for me I would cite one, Syria, which is like critical in our time.
Yes.
But France tabled the move to pass a resolution to refer Syria to the ICC.
Yes.
Russia vetoed.
In China, I think.
Yes.
Because of their national interests.
So there is no way you can stop saying there is a little bit of biasness on that particular front.
And in addition, we could easily deal with the issue of bias, as Professor Peter said at the very, very beginning. And I think also Professor Bakari, because one of the distinguishing characteristics of the Rome Statute, unlike the ICTR and ICTY, those two previous penal tribunals, for them the approach was, if there is a situation, then they get the first chance to prosecute. Right? It is only when they have difficulties, that's when they will ask a national state to do it. Now the Rome Statute has reversed that. Right? The Rome Statute insists that whenever there is a situation, whenever there is a breach, a genocide, war crimes or crimes against humanity, the first shot should be given to the country on the territory of which the crime itself took place.
I see.
Yeah, that's so it's very, very difficult to sustain this argument. Very, very difficult.
I tell you.
Yeah, it's very, very difficult.
Yes.
Complementarity, yeah.
Maybe I can add and maybe pose something for discussion from the professors. Is the issue of immunity ratione personae before domestic courts, and the issue that Professor raised of the arrest of al-Bashir. And I think this is the main reason that South Africa has come up and say we are withdrawing from the ICC just because we cannot balance competing international
For my benefit, was South Africa, is South Africa signatory to the Rome Statute?
Yes.
Did they ratify it? Did they domesticate?
Yes, they did domesticate.
Okay, I mean, time is really not on our side, but so what would be the one or two or three major issues why Africa is trying to withdraw from an organization which it created? Professor Kamanga.
Yeah, it's very basic, and it's the issue of politics, right? And the politics here is that, unfortunately, you have created a judicial body whose function is to encroach in those areas over which states are terribly jealous about. Right? That's the fundamental political problem with this ICC, good as it is. But Because, for example, one of the principles that it pursues is that there is individual criminal responsibility, irrespective of the person's position in a political party, in the military, in the civil leadership. What does this mean? This means that it exposes your high political leadership to international prosecution. That is one. But also the embarrassment or the humiliation, if you want, of having this person put on a plane, right, and taken elsewhere.
To hell.
Right? Whereas
we have examples, though.
Yeah, whereas the judicial system requires that the person should be tried before national courts. So this is the fundamental problem. This court, its function encroaches in issues that are sensitive for states.
Is it sensitive to the AU as well? I mean,
in a way, indirectly, yes, because these are your members now.
I think what Professor Kamanga is saying and what Professor Bakari said is important to note. At what point in time do we start saying that the ICC is biased?
Yes.
It is.
It's only for Africa. It's racist. These are some of the ways the people use. Yeah.
But the timing is important. It is when a head of state, al-Bashir, is targeted. When a head of state, Uhuru Kenyatta, is targeted. When a deputy vice president is targeted. Because of what Professor Kamanga said, Article 27 of the Rome Statute, immunity. For the first time in the history of international law, ICC is historical in the sense that there is no immunity as far as you have committed a crime, whatever your position is, you will be indicted. So the African states tried to get around immunity, saying that, we should defer these cases until the person leaves office. But these Africans never leave office. They've
become presidents for life.
They've been there for 30 years. 36, so they
leave office after death.
So it was just a clever way, and that's why the Security Council refused, because they took the matter to the Security Council asking for difference of the cases.
Yes.
So I think the major issue is immunity. That's why we are talking of leaving ISIS. It's immunity. Because after immunity, I don't think we have time to discuss this.
No.
But
Next time.
Yes. But if you look at the issue of immunity, the institutions they have established after wanting to leave ICC, all of them play down the question of immunity. If you look at all the documents, the documents of Malabo, which I think Gift knows better than all of us, Malabo and the others, all of them now grant immunity to heads of state. They even increase the types of crimes. ICC deals with only 4. Malabo, which is Malabo Protocol, which is now supposed for Africa to deal with the crimes, serious crimes, have 14 crimes actually, not 4. 14 crimes, you name them. But the major thing, grant immunity.
Grant immunity. Well, my dear panelists, I mean, it surprises me if Africa, which is the founder member of the ICC, wanted to withdraw, and these leading countries have already indicated they are going to withdraw, including South Africa. But if without an alternative national court to handle these cases, I mean, will this be fair to the citizens of this country when a leader commits crimes, not necessarily international, but against human rights?
In the first place, Mzee Simbe, it will take us back to pre-ICC.
Yes.
Because then we'll be falling back on ad hoc approaches, which history has shown are not effective.
Yes.
So that's where we'll be. But that's one. But two, withdrawal itself doesn't seem to me to be the most practical thing to do, because while the statute allows for withdrawal, right? Joining is voluntary, but also once you've joined, they cannot force you to remain there. You have the right to withdraw. But first of all, there are procedures. First of all. And secondly, your withdrawal will take effect after a period of 12 months after the notification has reached the Secretary General. And thirdly, you will still continue, even after having withdrawn, you will still be obliged, right, to bear the obligations for the time that you were a member. Yeah, so if you're required to pay subscription, you still have to pay subscription. If you are required to cooperate with the prosecutor to find somebody to arrest them, you will still be obliged to do that, because those are crimes that took place during the tenure of your membership.
Okay.
I think you have mentioned one thing very important, that who are demanding for withdrawal.
Yes.
It's not the African people. It is the African politicians.
Political elite.
The political elite in Africa. They want to be immune.
That's what Professor Peter was emphasizing.
Yeah, so if you are going, for example, to conduct a survey probably anywhere in Africa, people are very much supportive of this, because this is the kind of the last resort, actually. If there is a problem, I mean, at least it serves some kind of sort of deterrence, you know. It is not so effective, but we don't have, I mean, deterrence measures apart from this one, so to speak. So I think it's very important. And please allow me to read a quotation from Askofu Desmond Tutu.
Okay.
He's saying that African leaders behind the move to leave the ICC are effectively seeking license to kill, maim, oppress their own people without consequences. That's what they want to do.
Yes.
I think the best position is the position which was taken by the government of the United Republic of Tanzania.
In fact, I was going to ask you very quickly.
In this statement given by His Excellency Ambassador Tuvako Manongi,
Yes.
he said, he says in short that ICC is not perfect. It is all right. Only that what we need is to dialogue. Let us look what are the problems and try to sort out.
And we are the largest bloc in the
state
parties.
parties.
Yes.
So the issue is not to leave, but to dialogue. Let us discuss.
Negotiate
I think
a
that
better
is the
deal.
best position taken by the
Yeah, I think that's the proper position. And
Thank God my
we
country,
should also,
I mean, our country. our country has
we
that
should also
position,
appreciate the fact that, I mean, the institution itself is not that old. I think it's hardly
2002
actually hardly 10 years.
2002.
Yeah? So because the first prosecutor was appointed, I think, in 2003. Luis Ocampo.
Yes.
Luis Moreno Ocampo.
It was not very popular.
You know,
Anyway.
so the first years, these are formative years. It should have a lot of problems, including actually even harmonizing the legal system. You have different traditions of legal system. You have the Francophone, you have the Anglophone, you have the Lusophone. So many, I mean, problems. I mean, so even the first years, I mean, we should appreciate, I mean, the fact that with all the problems that it has been encountering, but we should understand, I mean, that situation, that it was in a very critical situation of establishing itself. So it's not that the institution is well established. So I think this is the time now to review, I mean, the problems and finding solutions, I mean, to those, I mean, tricky problems that are affecting the institution.
I have two last questions, and I'm being warned time is against, but maybe we should combine this and you can respond to this. So, do you think this intention to withdraw is the beginning of the end of the International Criminal Court? And can it be salvaged? Very quickly.
I don't think it's the beginning of the end of the International Criminal
Okay.
Court. Because there are only 3 countries that have expressly stated their desire to withdraw. And
many might follow.
Yes, probably Kenya would follow, but most other countries have expressed their desire to support the ICC. And I don't think it's the end of the International Criminal Court.
Can it be salvaged?
Yes, through negotiation, diplomacy. That's the only way we can go about.
Last question. We'll go this way. We start this way because we've just your last speaker. Now, what is your professional advice to African leaders on withdrawing or not withdrawing from the International Criminal Court? Very quickly.
Okay, I think they shouldn't withdraw because we don't have an established alternative to the ICC at the moment.
Okay.
The Malabo Protocol has only received 9 signatures without ratifications.
Okay.
Domestic courts are yet to be adequately to prosecute. So they should stay in, but they negotiate and see how best they can resolve the issues.
Where do you place the African Human Rights Courts in Arusha?
that one is yet to come into play because it was given criminal jurisdiction under the Malabo Protocol of 2014. But the protocol hasn't had any ratification.
Professor, very quickly, your professional advice.
My professional advice is to keep, to fight impunity and remain in ICC and dialogue over what other challenges facing ICC, not to run away from problems, but to face problems if they are there.
Absolutely. Face. Professor?
Well, I mean, I'm very much actually disappointed by the decisions that are taken by African executives.
Yes.
Like South Africa, for example. It filed its intention to withdraw without even consulting the parliament, the national parliament. I think this is something outrageous because the domestic, the parliament ratified the Rome Treaty. Of course, it was the executive which signed the statute, yes. But the parliament had ratified it. And now you have the executive, taking a decision without even consulting the parliament. I think this is something very outrageous.
A bit abnormal. Very quickly.
Yeah, two things I fully support. I think the statement made by the Tanzanian ambassador to the UN, I think his recommendations are very sound. They should be given serious consideration. Professor Peter has summarized it well, what is in the ambassador's report. But lastly, I'm not worried the least about these withdrawals, because withdrawals are made by governments and governments are passing. So if a country, an executive decides to withdraw, they will be able to do so. It's their sovereign right, but probably the next government around will easily reverse.
Who wouldn't mind about immunity?
Precisely.
Well, my panelists, thank you very much for your analysis. I'm sure the viewers out there who will be watching this program will really understand what the ICC is and the issues of blaming of the ICC or calling it all sorts of names and all that.
Apportioning blame
blindly will one of these days end.
So.
And the example you gave in the Dallas, people stealing a phone or Karanga saying we have to take him to ICC. I think this was belittling the importance of the ICC because of ignorance, I understand. So thank you very much. And I like your last advice to the African leaders that we should stay in this, argue out, let's discuss, which is the position of Tanzania. We're very grateful to the ambassador to the United Nations, Mr. Malongi. Well, thank you again, my panelists. Viewers,
thank you so much.
You heard the views of my panelists here. Very rich, very powerful about the ICC. And their conclusions, kind of professional advice, again, very fundamental. We hope something will be taken to account seriously. Well, but the defense of the International Criminal Court, demise actually, court commonly referred to as the ICC, has further been threatened by planned withdrawal of 3 African countries, including South Africa, and recently Russia, which has also announced its intention to withdraw from the ICC. Although it has not it accepted the Rome Statute, but it has not ratified. The ICC has been accused by some African countries of being biased against Africa. And it has not as yet prosecuted cases outside the continent. But you heard from my panelists here that is unfair because some of these countries in Africa have themselves referred cases to the ICC. Of course, although the current prosecutor, as you well know, my panelists here confirmed this, is an African lady from the Gambia, which is in the forefront of withdrawing. Whilst Africa withdrew from the ICC has been ongoing deliberation in the African Union, it seems there is no alternative court in the offing by, trying to international court to try international crimes, let alone having the capacity to do so, as you heard from my panelists here. The question is why Africa wants to withdraw from the ICC, which she, together with the other 124 countries, was a founder and signatory to the Rome tattoo. Does threat by African countries, except Nigeria, Tanzania, and Senegal, indicate the end of the ICC? And can it be salvaged? You heard my dear lady here saying, no, it's not the end, and it can still be salvaged, as all the professors here said. We just need to negotiate. It's not good to run away from the problem, but be in there and resolve the problems. After all, Africa is the largest bloc in the Rome Statute, as it were. Tanzania, of course, through its ambassador to the UN, stated its position to the General Assembly that the court's tumultuous relationship with Africa has sparked concern of a mass exodus from the ICC. And he says this should not be the case, as supported by panelists here. Let us hope Africa, through the African Union or individual countries, will salvage the ICC, which, as we said, it can be salvaged, and renegotiated and continue to strengthen, if not the national courts, but at least the ICC. That's what we have for you today. Until next Sunday at 21 hours and on Thursday at 15 hours for the repeat program. On behalf of my panel, Professor Koti Kamanga, Professor Mohamed Bakari, Professor Chris Minor Peters, and Dr. Tubi Gift Kweka, and of course my TBC Television Center crew. Thank you, viewers, and goodbye.